Dictation starts. Operation of Rent Act cannot be extended to a tenant in sufferance vis-a-vis Surface Act due to operation of Section 13 in bracket 2. Read with Section 13 in bracket 13 of Surface Act. Para. A tenant allegedly entered into an oral agreement of tenancy before the mortgage deed was entered into between the borrower and bank/creditor. The records also do not demonstrate that the appellant tenant has been able to prove his status as a valid leaseholder to merit the protection sought for. Admittedly, an equitable mortgage on the secured asset was created by the respondent number 2, borrower/landlord, by depositing title deeds with respondent number 2, bank, on 20th 5, 2000. However, the date of creation of the tenancy is not established. The appellant tenant, while seeking protection before the Small Causes Court, stated that the premises were let out to him in January 2000. But the court noted that the appellant tenant produced photocopies of rent receipts for the period of 2001 to 2011. Contrarily, the appellant tenant has stated that he entered into the tenancy in October 2005. The claim of tenancy made by the appellant tenant is not supported by registered instrument. The appellant tenant has to produce evidence of payment of rent, property taxes, etc. Furthermore, if the rent and permitted increases were payable, then the quantum ought to have been mentioned. In addition to the above, the claim of tenancy could have been substantiated by relying upon other tax receipts such as BMC tax, water tax, electricity charges consumed by the tenant, etc. However, the appellant tenant has only submitted Xerox copies of rent receipts. The additional protection cannot be provided under the Rent Act to the appellant tenant. The lower courts are correct in ordering delivering of possession to the respondent number 1, bank, as the tenancy stands determined. The present appeal arises out of the impugned order dated 31/12/2014 in case number 42/SA/2012 of the Chief Metropolitan Magistrate, rejecting the application of intervener, who is the appellant tenant herein, seeking to stay the execution of order passed under Section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement over